Okay, so I wanted to go over a short sort of couple paragraphs in this book, Fiction and the Languages of Law, Understanding Contemporary Legal Discourse by Karen Petrosky. And there's a section called Fiction as Epithet in this book here, and I found it a bit interesting. It's in relation to uh, case law and how fiction is used to get from point A to point B. In the end of this section, which is 2.2.2 on page 30, she goes over the idea that fiction is used by judges or jurists in general in court cases to get from one point to another point. And in a few of my other books, I've mentioned how some writers who have reviewed court opinions will tell you that some uh, judges who write these court opinions are using fictions in a way that do not get them properly from point A to point B. They use them just to make a point or just to persuade or to promote their bias through their persuasion, their persuasive language. And I refer back to Constitutional Law as Fiction, Narrative, and the Rhetoric of Authority by LaRue. And in chapter 1, on the very first page, he talks about how the proud towers of the law are built not on level bedrock of fact, but on the perplexed terrain of fiction. That judicial opinions are filled with stories that purport to be factual, but that instead are fictional, and furthermore, that these fictions could not be eliminated without crippling the legal enterprise. So when I read you this, and I'm just going to read it, it's not too long. When I read this to you at the very end, she basically makes the statement that fiction is used as a utility or a tool to help judges get from point A to point B in making their point, but that is not always the case. Okay, so we learned this in some of the other books and some of the other videos that I've talked about. So fiction as epithet. Although the justices do not always refer to fiction despairingly, usually the term is an apology at best. Like many related terms, it almost always implies an undesirable departure from reality or the facts. The justices often use these terms to justify rejection of other judges, justices, or parties' arguments. A justice may, for example, accuse other judges of letting their imaginations run wild by charging them with indulging in speculation, with being fanciful, or with deciding a hypothetical case. To accuse a judge of making a legal mistake, applying the wrong legal rule. A critic may say that the misbehaving judge imagined, invented, created, or made up the rule, implying an intentional departure from consensus reality. Sometimes a justice accuses a judge of dissimulation or pretending to do one thing while really doing another. To stress the futility of a misbehaving judge's illegitimate activity, the critic will say that the judge has created or gotten lost in a world of his or her own creation. Justice Thomas was the 2014 term's most prolific dissenter, and he repeatedly used this kind of rhetoric in his 2014 term opinions. The Teva Pharmaceuticals v. Sandoz, for example. He describes the governing legal standard, a perspective that patent law requires judges to assume the perspective of the skilled artisan, as contrived to support his broader point that applying the standard does not involve deciding any questions of fact. The fact of how a skilled artisan would understand a given term is a legal fiction. He writes, it has no existence independent of the patent claim, construction process, the process in which a judge determines a patent's claim scope based on the claim's language. There is no actual skilled artisan who formed an understanding of the terms of the claim. Thomas 10. Although Justice Thomas uses the term legal fiction, here he is not calling the skilled artisan a traditional legal fiction. Rather, he is describing the perspective as detached from actuality to support his point that appellate judges can inhabit the perspective despite their own detachment from the evidence presented in trial court proceedings. Justice Thomas does not always use the fiction label this neutrally. Dissenting in Obergefell, for example, he criticizes the majority's reasoning in this way. I have elsewhere explained the dangerous fiction of treating the due process clause as a front of substantive rights. It distorts the constitutional text. Worse, it invites judges to do exactly what the majority has done here. Rome at large in a constitutional field, guided only by their personal views as to the fundamental rights protected by that document. Thomas 2. This fiction, unlike the legally appropriate skilled artisan fiction, is illegitimate, according to Justice Thomas. Labeling the doctrine a fiction helps him to communicate his disapproval from it as a manner of speaking that allows judges to indulge their personal views and make up new rules. Justice Thomas is not the only justice to have used the word fiction to label things this way during the 2014 term, nor is he the only justice to criticize others for departing from reality. In his majority opinion in the skilled artisan patent case, Justice Breyer quotes similar language from the opinion of the lower court judge who took a position contrary to Justice Thomas's. Treva, Breyer 9. Justice Alito often criticizes other judges and justices for wandering away from reality. In his 2014 term opinions, a dissenting justice's assumption that voters can effectively control legislators by voting them out of office is fanciful and infected by improper speculation. An appellate court inappropriately indulged in a flight of fancy. The majority's claim that members of the public have come to rely on a particular Supreme Court decision is also fanciful. And a majority's decision is unnecessary, impractical, and arbitrary because it addresses a purely hypothetical question. Other justices use similar language in 2014 term opinions to criticize other judges for creating or willfully misconstruing legal rules. Justice Sotomayor criticizes the majority in Hine v. North Carolina for imagining a holding that is not rooted in the logic of the opinion on which the majority relies. She criticizes Chief Justice Roberts' dissent in T-Mobile South v. City of Roswell for inventing a process that turns judicial review on its head. Chief Justice Roberts, dissenting in Obergefell, describes the constitutional right to state-recognized same-sex marriage as a right imagined by the majority, contrasting it with rights actually spelled out in the Constitution. Justice Scalia was, of course, especially fond of colorful denunciations of this kind. A majority opinion: imagine a legal utopia, a world in which all lawyers are responsible and no lawyers make mistakes. Dormant Commerce Clause doctrine is brazen invention, a judicial fraud based on an imaginary commerce clause that leads to imaginary benefits. A majority's make it up as you go along approach has no basis in the act governing the case and will prove unworkable in practice. These critiques all describe other judges' activity as illegitimate because of its own deviation from reality, actuality, or fact, and its resulting susceptibility to personal preference and unpredictable variation. Sometimes when a justice accuses another judge or justice of pretending, the accusation is of even worse conduct, amounting to deception. A majority opinion pretends to review the appellate court's exercise of discretion while actually reviewing the trial court's legal analysis. A majority's fidelity to controversial precedent involves the pretense that the precedent was legitimate. In the instances, justices describe judicial activity as involving something close to deliberate falsehood. Pretense, in the sense, involves not just a judge's imposition of his or her personal preferences, but also the judge's deliberate concealment of that activity. The justices used similar language on other occasions during the 2014 term. The following pages will revisit many of the examples cited here and introduce others as well. To be sure, the justices sometimes use similar language more neutrally or even positively. As Chapter 5, in particular, will explain, some justices explicitly instruct readers of their opinions to imagine or suppose, and most of the justices will cite works of literature, usually prose fiction, now and then in support of a point. Still, the label fiction usually imparts a negative tone to a justice's description of another judge's activity, suggesting departure from a solid public world of fact into a private, often shifty world of imagination. The justice's use of this family of terms is consistent with legal scholars' use of them. In her majority opinion in Los Angeles v. Patel, Justice Sotomayor cites a 2011 Law Review article by Richard Fallon, Fact and Fiction About Facial Challenges. As the article's title suggests, Fallon wrote it to correct misperceptions about such challenges, in particular, what he considered a tendency to underestimate the frequency of successful facial challenges to the constitutionality of statutes. He describes these misperceptions or fictions as a misunderstanding of practice, a kind of illusion. He attributes the illusion both to judges themselves, who describe facial challenges as disfavored, and to observers of the court, who take the descriptions at face value. In this argument, fact is to fiction as truth is to possibly understandable mistake. Scholarly discourse, like judicial discourse, should aim at the former and seek to unmask the latter. This kind of argument depends on understanding fiction as detached from reality and impractical. Somewhat like Fallon, this book argues that understanding fiction in this way involves misconceiving it. This understanding oversimplifies the structure and functioning of fictional discourse, and the oversimplification has implications for our understanding of other modes of discourse, including legal discourse. Unlike Fallon, however, this book does not define fiction in absolute opposition to fact. Recent work on the dynamics of fictional discourse supports a more nuanced understanding of the relationship between fiction and fact. As the next section explains, interdisciplinary work over the past several decades has been converging on an understanding of fictional discourse and practices of make-believe that acknowledge their utility instead of condemning them as frivolous and deceptive, and unlike similar earlier accounts like that of Hans Weihinger, explain their operation and in some detail. And that's the end of what she says. So again, so she's talking about how fictions are used in court opinions and by lawyers and attorneys or justices, and they're used as a tool to get from point A to point B to help them resolve an issue. But as I said at the beginning of the video, there has been a lot of studies on the use of fictions in legal discourse, and that there are a lot of um, lawyers, attorneys, judges, justices, and such who misuse the tool that they're given. They misuse the fictions, the hypotheticals, and they might state one at the front, their proposition, for example, and then they don't follow it up with facts that really line up or support their position in the first place. So fictions aren't always used properly. It depends on who you're reading and what they're citing as their sources for unsupportable or supportable fictions as a tool. And so you have to read a variety of things to really get a good idea of what the writer means by fiction and what cases they're quoting. And then you have to go back and look at the cases. But there has been one book that I read, I think it was called Minding the Law, by Amsterdam and Bruner, who talk about how they had some students go over some court opinions, and how the students came to the opinion that the fictions that they were using didn't really support the outcome that they were saying was the proper outcome for the case based on the fictions they used. Another writer said, there's this hypothetical reasonable man to which we're all um, measured against, and who is this reasonable man? Who decided that what he was doing was reasonable, and why are we all supposed to measure ourselves according to this fictional reasonable man that's made up in one judge's or attorney's mind? Okay, so just something that I was reading, and I wanted to read this to you guys about fictions and court opinions. Some people support them, some people don't. Sometimes they're in a court case law, and when you read it, it sounds good, but then when it's really scrutinized by scholars and students and writers and people who study language, they find that the fictions that these writers are using have a lot of problems and don't really support the purpose of using them in the first place. Okay, so it's just something I wanted to put out there and have you guys keep in mind. This is the book here, Fictions and the Languages of Law. I bought this book on Amazon. I don't know if it's still there. I checked archive.org and I did not find it on there. I checked online for any PDF and it wasn't on there either. This is at Rutledge, Taylor, and Francis Group, and this book here is 43.96. It says you can save 10.99. I don't know how. You'll have to go there and figure it out for yourself. So okay. Have a great day. Like, share, subscribe. If you don't hear from me again before the holidays, Merry Christmas, Happy New Year, and I'll be seeing you guys again soon.